Hey, Jack Ryan here with another session of the Legal and Liability Risk Management Institute's Legal Update and Best Practices series. Welcome. Hey, the issue I want to talk about today is constitutional audits. But I think it's important to talk to officers and to mention that our actions have been audited for a long time, and they've taken very, different formats. One, courts audit our actions all the time. So, for example, an officer who seizes evidence, whether it's subject to exigent circumstances of some sort, whether it's subject to a warrant, you're going to end up in court, and a judge, through a defense attorney who's going to challenge your actions, a judge is going to audit your actions and decide whether or not you acted consistently with the Fourth Amendment to the Constitution. Same thing with confessions. When we get to court, the confession may be challenged by the defendant, and then the judge will audit our actions with respect to whether or not we acted consistently with the Fifth Amendment to the Constitution, or perhaps the Sixth Amendment right to counsel under the Constitution. So our actions have been audited for a long time. Several years back, we started to see citizens begin to audit our actions, and some of the initial audits, and some of you may recall this, is somebody would come into the police station to make a complaint, or the sheriff's office to make a complaint against an officer, and they'd want to talk to a supervisor, and before you know it, the supervisor is on a camera, being seen throwing them out of the police station, refusing to take the complaint, or maybe even worse, in some cases, the person is arrested for making a complaint. And those were essentially audits of the internal affairs process. And in some sense, there were audits of a person's First Amendment rights to make a complaint against an officer, because remember, there is this idea that the First Amendment allows people to gather information and disseminate information about law enforcement. Now, I think at the outset, we should remember that essentially what the argument is in these cases, particularly where an arrest has been made, is that the arrest is in retaliation for an exercise of First Amendment rights. Hey, we're going to open up with a couple of videos. So take a look at these. One is on Second Amendment, because I think that's an audit that we're starting to see a lot of too. And the second one is on First Amendment rights. Now, remember, these videos are not to in any way say that the officers didn't do their job correctly. It's not to embarrass the officers. But these are videos that are on YouTube. You can see hundreds of them. Some of you have been caught up in it. And unfortunately, when officers get caught up in these videos, sometimes they don't look very good. And again, this is not to in any way talk about these particular officers. It's just to show the kind of challenges that citizens are putting before officers in these cases.
And then can you please let me go about my business? Thank you. I was just informed I'm not being detained, so I'm going to continue on my walk.
Do you have any ID on you?
Yeah, I'm a citizen exercising my rights. I'm not a part of anything, so please don't group me with anybody. So thank you. Yeah, can you please tell this gentleman to back up off me, because I'm feeling threatened and I will use excessive force. I will use excessive force.
Sir. Sir.
I sure do. It's an AR-10 Smith & Wesson 308 caliber 7.62, sir. I do know what I'm carrying.
Okay, just calm down, okay? You're okay.
No, ma'am. Can I continue about my walk since y'all have taken care of the situation?
Just wait till this officer can talk to you.
I was informed I'm not being detained, and I would like to continue my walk, please.
But can we get your ID?
You're gonna hit me? I'm sorry, you're gonna threaten me, officer?
Are you coming to cause a scene right now? Because I'll arrest you for disorderly instead.
Why? I'm doing what I'm doing my...
No, you're attempting to cause a scene here with...
No, I'm not. You just threatened to hit me.
You most certainly are.
You just threatened to hit me. You threatened to bash me.
201 from 222.
I don't get threatened in public. Sorry.
Did you respond to in front of the box one? Stop taking my photograph.
Next to the office. Be a gentleman.
Yeah, well,
Yeah.
that goes both
That's the
ways.
problem right there.
That goes both ways.
Get that camera out of my face.
I'm on public property. I can do what I want.
That's not public property.
I am now.
You are so rude. Are you recording me?
I'm in public. I'm a news person.
Hold on. Are you recording right now?
I am videotaping, which is in my constitutional rights.
It most certainly is not.
It certainly is. In public, I have the right to record video and ambient noise. And
This is not
law
ambient noise.
enforcement has no respect, no expectation of privacy when you're doing your job. You're in uniform. You just threatened to bash me in the face, officer. That is a crime. Just because you have a badge does not mean you can threaten people to bash them in the face.
I hope you're. What crime was that?
I'm going to continue to roll on this, just so you know. The Boston police tried to. This is case law, right here. You got to study up on your law.
Oh, I forgot that you're a policeman.
You don't have to be abusive to me and threaten
Oh,
to
abusive.
smash me in the face with my camera because I took a photo and asked a question.
That's not what.
This is the United States of America. Last time I checked, and I'm in public, and you just made a bunch of noise towards me, and I don't appreciate it.
I walked away from you and you followed me. Okay, that's what happened.
Hey, let's talk first about the concept of a Second Amendment audit. And I'll tell you that the Second Amendment audit is the more difficult of the two in this sense. The Second Amendment grants all citizens, except those who are disqualified based on some valid disqualification, to possess firearms in their homes. That's what really the Second Amendment clearly establishes, that a person has the right to possess a firearm in their own home. Now again, remember there are some folks that are disqualified. We all know about the domestic violence disqualification. So a person that's been convicted of certain domestic violence offenses is forever prohibited from possessing a firearm. That's under 18 USC 922G, and several states have also put a statute in place that addresses that. Certain people that have been determined by a court to be mentally incompetent can no longer possess a weapon as well. So again, possess is not the same as carry, and carry publicly. It may be, certainly the ability to carry on private property. But states can have laws that impact a person's ability to carry a weapon, and that's the difficulty in doing any kind of training that will go nationally on this. So what I need to say to you at the outset is you have to have a clear understanding of the law in your state and whether or not a person has, by statute, a right or a restriction on whether they can carry in certain areas. So, for example, some states have, and there's a breakdown of this, but some states have, hey, you cannot carry a handgun in a public place. Some say you cannot carry a handgun concealed in a public place. Some say you cannot carry a long gun in a public place. And then there's other laws as well that maybe say, hey, you can't carry a handgun in a federal building. You can't carry a handgun on a plane. So there are things, or even a long rifle for that matter. So you have to have a clear understanding of the law in your state so that you can then deal with this Second Amendment audit of the firearms. So if your state, for example, allows open carry and somebody's walking down the street with a rifle and your state does not restrict that, then they would have a Second Amendment right to carry that rifle down the street, and your actions in taking enforcement action against that individual may be in violation of the Second Amendment. If you were to arrest that individual, we would call that a retaliatory arrest for an exercise of Second Amendment rights. I think more often and more problematic as far as on an everyday basis for law enforcement is what we see in the second video. And that is people who are filming officers in some ways, and again, whether you agree or disagree, baiting officers and trying to get officers to take enforcement action against them simply based on their videotaping or video recording officers in a public place. So we're seeing a lot of those cases. And I'll tell you, they've taken a turn. Sometimes they'll come into your police station parking lot that is not marked private and no trespassing. And they'll come into your police station parking lot and start filming officers' personal cars. They'll start filming undercover vehicles. So again, if a department wants to, or a sheriff's office wants to restrict that, then they have to put signage up. They have to close that parking lot as a public area. And they would have to take steps to do that before they could take enforcement action on the person who walks into your public lot that's not signed. Because again, it is a public building. So we're seeing a lot of this in public buildings as well. I think the two main cases that most of the circuits cite actually came out of the First Circuit. There were two of the early cases. The first one is Glick versus Cuniff. Simon Glick was walking by the Boston Common in Boston, Massachusetts, and there's something going on in the Boston Common. There's actually some officers arresting three individuals, or three officers arresting an individual. And Simon Glick actually hears a man yell out, "Hey, I see you, you're hurting him." And Simon Glick says at that point, he decided to film the officers, very open and notoriously. I think the court says he was about 30 feet away, but he's a distant distance. It's certainly beyond 10 feet. And he actually lets the officers know that he's filming, and his mind or his theory is that if he lets the officers know that he's filming, then they won't, use excessive force on this gentleman they're arresting. Bottom line is, when the officer gets done arresting the person that he's trying to arrest, one of the officers comes over to Simon Glick and asks, "Was that also recording sound?" Simon Glick says, "Of course it was recording sound," at which point the officer arrests Simon Glick for violating the Massachusetts wiretap statute because he was intercepting oral communication in a conversation that he was not a party to. Even though he could hear it and it was in a public place, I guess the officer didn't take that into account, or maybe the officer was not familiar with all the legal issues with that particular statute. The bottom line is Glick gets charged, the criminal charge is thrown out almost immediately, and then Mr. Glick brings a lawsuit against the officer. Bottom line, this was a case where the First Circuit, in looking at the case, they said some things that I think are important. They said, hey, look, one of the foundational issues with the First Amendment is the right of citizens to gather information and then to disseminate information about government actors. That's under the First Amendment, the right to gather and disseminate information. And they said certainly filming is a way to do that. They also said some other things. They said, look, every citizen has a First Amendment right to verbally criticize and challenge an officer who's making an arrest. And I've seen these arrests, and you've seen these arrests over the years, where you've got somebody across the street from an arrest, they're yelling and screaming at the officer, maybe even using vulgarity, and the officer, after they make the arrest of the individual they're dealing with, they go across the street and they arrest that individual. Well, the problem with that is there's an old U.S. Supreme Court case, Houston versus Hill, where the Supreme Court of the United States, Mr. Hill was doing exactly that, and the Supreme Court of the United States said, Mr. Hill's got a right to do that under the First Amendment, and you can't arrest him for it. So we have that old case that says that, yet from time to time we still see officers making arrests for somebody who's across the street yelling vulgarity at them. In fact, there's another Supreme Court case, I think it's out of New Orleans, where the court actually would suggest that officers, even with fighting words, have to have a thicker skin because officers are trained. So the First Circuit looks at that and says, hey, a person has the right to verbally challenge and criticize an officer who's making an arrest. Certainly they have the right to film the officer and to record both audio and video with respect to an officer who's making an arrest. So again, they put that out there. They do say something else though, and this too is important. They say, hey, look, this arrest in the Boston Common, and where Mr. Glick is a distance away, is not like, say, a car stop, which may be fraught with danger to a police officer. And the Supreme Court has recognized in some other cases, Arizona versus Johnson, which is a case where a guy had a gun in a car, has recognized in some other cases that traffic stops are dangerous. So that brings us to the next case, because in the next case, officers were dealing with a traffic stop. Again, it's a First Circuit case, but again, these were foundational cases that are now cited by all the other circuits. Garrick versus Began is a case out of Ware, New Hampshire. And what happens in that case is Sergeant Kelly makes a car stop late at night, and he stops, is pulling over this gentleman, but these two cars are actually traveling in tandem together, and one is Miss Garrick. Miss Garrick also pulls over during the stop, but Sergeant Kelly's car is between his subject car that he's trying to stop and Miss Garrick, who's behind him. He first approaches Miss Garrick and lets her know, hey, look, I'm not stopping you. You can go ahead. She says, well, I'm going to stay here and I'm going to film this because I'm with him. I'm on my way to his house with him. And he says, look, you can't stay there. You're going to have to move your car. Now, Miss Garrick's story is that she told the officer, okay, well, I'm going to pull over into that school parking lot over there across the street. And she said, the officer said, that's fine. Remember, when we look at these cases, a lot of these written decisions, we're looking at the plaintiff's version of events, because if the court grants the officers what we call summary judgment or qualified immunity, the plaintiff is never going to get to put forth their evidence in court. So before a court can give officers summary judgment or qualified immunity and dismiss the case, they got to look at it from what plaintiff said happened. So Miss Garrick says, the officer says, that's fine. The bottom line is she goes over into this parking lot, and again, I think the court says it's about 30 feet away from where the officer is dealing with the traffic stop. Now, there are some things going on with the traffic stop. It's late at night. Sergeant Kelly, when he approaches the car, he learns that the man has a CCW permit, a concealed carry permit, and he's got a gun in the car. Now, again, there's no threat with the gun. Other officers respond to the scene. There's no issue ultimately with the gun, but the bottom line is it does heighten the nature of this traffic stop. So the bottom line is Miss Garrick is out there with a video camera. It's not even a phone. Ironically, the video camera doesn't work. It doesn't record. So that's something that the court does mention. She's behind a fence. She's videotaping. At some point, an officer comes over and asks her what she did with the camera, because at some point Sergeant Kelly told her, hey, get back into your car. When she was standing by the fence, she did that, but she continued to hold the camera up. But by the time another officer comes to her, she realizes the camera's not working. She's put it in her center console. The officer wants the camera. She refuses to give it, and ultimately she is arrested. And she's charged with violation of the New Hampshire wiretap statute for interfering with an oral communication that she's in a conversation she's not a party to. Ultimately, she didn't do that, and for the same reasons as in the Boston case, those charges were not prosecuted by the prosecutor. He dismissed the charges. But the bottom line, now it gave the First Circuit an opportunity to look at a traffic stop. And the issue for the First Circuit on this traffic stop was a little bit different. You know, they said under Miss Garrick's version of events, she complied with the officer when he told her to move from behind him the first time. And according to her, he said that's fine if she went over in the parking lot. She complied with his order to get back in the car. Here becomes the linchpin in this case. The court said, according to Miss Garrick, Sergeant Kelly never told her to move from the parking lot, never told her that filming was in any way interfering with him. And so, without that kind of order, she has the right to film the officer in a public place. Now, I will tell you that the cases say, and this is something to remember, the First Amendment is not absolute. What do I mean by that? Well, and it's mentioned in these cases. We can place reasonable time, place, and manner restrictions on a person's exercise of First Amendment rights. Now, just by way of example, let's suppose that you're out in the middle of the highway, there's a bad crash, and a person comes and pulls up on the highway. They're not there to help. They simply want to get out of their car and film the action that's taking place in this accident. Maybe they want to, put it on YouTube, or they want to give it to the news media later. Maybe they're a freelance reporter. Now, hey, I got to tell you, the case is made clear. You can't make a distinction between somebody who's a reporter from a news channel and just the average citizen. There's no difference between the two with respect to the right to gather and disseminate information. But reasonable time, place, and manner. You could tell the person who has stopped on the highway, particularly where, most of our highways have signs, no stopping, no pedestrians, things of that nature, no bicycles, and no stopping except for an emergency. This person's not involved in the emergency. It would be a reasonable time, place, and manner restriction to tell that person they have to move on and get off the highway. Another example would be, there are going to be cases where a person does interfere with the officer's ability to carry out their mission. There are going to be cases where the person interferes with the officer's safety and the safety of the individual the officers are dealing with. So I give this example sometimes when we're in a classroom. If I have a person that's standing right next to me and I'm doing a field sobriety test on them, and I have a person within 2 feet who's then got their phone up and is trying to film my field sobriety test, remember that's dangerous to me and that's dangerous to the individual, because anytime we allow somebody to get that close, they have access to our weapons, they have access to assault us, things of that nature. At the same time, particularly if they're making noise in the way of verbal aggression, or not even aggression, but verbal statements. Hey, buddy, you don't have to comply with that officer. Officer, who do you think you are to stop him? Those kinds of things. Then that would interfere with our ability to carry out the field sobriety test. So we could place a reasonable time, place, and manner restriction on that individual. Now, it's not because they're filming. That's not why we're doing it. Remember that this is an important piece of this. We're doing it because of their interference with us from a safety standpoint and our ability to carry out the function. So one of the things that an officer would have to do with this individual before even considering enforcement action would be, sir, you're interfering with my investigation and my safety. You can continue filming, but you have to get across the street. You have to move back 10 feet, whatever the case may be. But here's the thing that officers need to understand. That video is going to tell the story. So if they're already across the street and you make that kind of statement, you lose. However, if they are right in your space and they are interfering, the video is going to tell the story. Maybe even the officer's got a body cam on and that video is going to tell the story. So the courts do say there's a reasonable time, place, and manner restriction that officers can place on First Amendment rights. The thing that I would say to you is this. One, make sure you give the person a warning. That's going to be key in these cases. Make sure that you have a case where the person is absolutely positively interfering with you. And if they're not, then just please forget it. These cases are losers where we retaliate because the person is filming. And remember that we're not going after them for the filming itself. That's not why we're doing it. That should never be why we do it, because they have the First Amendment right to do that. It has to be because there's some other underlying criminal charge. And again, an obstruction charge is appropriate where they are in fact obstructing. I do want to mention a couple of other things that come out of some cases. I want to mention Sharp versus Baltimore. And in Sharp versus Baltimore, officers are making an arrest at the Pimlico racetrack. And while they're making an arrest, Mr. Sharp is filming them. After the arrest is made, an officer comes over to Mr. Sharp and says, I want to see the video. Mr. Sharp initially refuses. There's some argument that goes back and forth, and finally the officer either threatens to take the phone or threatens arrest, and Mr. Sharp turns over the phone so the officer can see it. The officer walks away briefly with the phone. He says to show his supervisor. When he comes back, he says, you're all set. There is no evidence on the phone. And the officer is correct, because the officer has deleted every video, every photo that Mr. Sharp has on the phone. Mr. Sharp ends up bringing a lawsuit. And I'll tell you, this is very unusual. You know, the United States Department of Justice jumps in on a lawsuit brought by an individual. I've never seen that happen before, but I saw it happen in this case. They did a statement of interest letter to the parties and to the judge and said, hey, this is an important matter when officers interfere with First Amendment rights. We're not saying it happened, but if it did, it's an important matter, and we have an interest in this case. And before the case was resolved, the United States Department of Justice sent a memorandum, and in the memorandum, they said, hey, look, if you settle this case, we think there's certain things that should be put into place in this law enforcement agency and in all law enforcement agencies with respect to filming. One, officers need to be trained, and officers need to be directed by policy that every citizen has a First Amendment right to video and audio record an officer in a public place. And by the way, an officer should never interfere with an individual who is recording in a public place. There's even some lawsuits on that where the officers in some way block the individual or block the scene in a way that's unnecessary. So there's even those kind of cases. They said, hey, we are going to say that the department should have a policy in place and train officers that if they get a case where there is essential evidence on that phone, or at least the officer believes, probable cause to believe there's essential evidence on that phone, in that case, the officer may be able to seize the phone or the recording device, but it's got to be very brief. It's got to be just that amount of time it takes to get a warrant and to download that information. And officers need to be directed. If that happens, if you get that kind of case with the essential evidence on the phone for which there's probable cause in which you can obtain a warrant, you better give the phone back without any deletions or manipulation of data on that phone, so you can't touch the recordings that are on the phone. So again, Mr. Sharp got $250,000. There were a number of changes made in the Baltimore Police Department, and so we do see those kinds of cases as well. Hey, the bottom line is this. All persons have the right to video or audio record officers in a public place. The police station, the sheriff's office, the public areas of those buildings are a public place. So you do not want to get involved in saying, hey, this is our building, you can't record here. This is our parking lot, you can't record here. Now, if a person stormed into the private areas of your building, we're going after them not for filming, we're going after them for the fact that they have gone and trespassed on a private area of the building. The same thing with our parking lot. If we've got our parking lot signed, and again, I was out in, I think it was Broken Arrow, Oklahoma, and in Broken Arrow, they had the law enforcement parking lot, they had it fenced off, and then, maybe because of this very issue, they got that black fabric and it was on the fence, so that a person would have no way of filming the officers' vehicles through the fence. Again, those are steps that an agency can take legitimately, but what you can't do is if you have a parking lot that is open, not signed, not private, then it's a public place. It belongs to the city. Citizens can walk there. If you wouldn't stop a citizen from walking through that lot, you can't stop a citizen from videoing in that lot. And that becomes the bottom line. So again, hey, knowledge is power. Officers need, and again, this is not the fault of the office. As I said, I've shown a couple of videos. This is not, I'm not blaming those officers anyway for the way those situations developed. Officers need more training on some of the other amendments to the United States Constitution. We do an awful lot of training on search and seizure, on use of force. Those are under the Fourth Amendment. We do a significant amount of training on Miranda, the Fifth Amendment issues, and even the Sixth Amendment right to counsel. But we've done very little training over the years on First Amendment issues, Second Amendment issues, and before officers take enforcement action that may impact those amendments. Because remember, our oath of office isn't just to uphold the Fourth Amendment to the Constitution, it's to uphold the entire Constitution. So before we take enforcement action on even anything within the Bill of Rights, the individual rights provisions of the Constitution, we have to make sure that we're not in some way violating our oath or impacting those rights in a way, or making an arrest in retaliation for an exercise of those rights. We want to look for, if there's in fact an underlying offense, then that's a different story. Hey, thank you for listening. Have a great day, and please be safe out there.